Hello, this is Sara Bazzigaluppi with the Chapman Law Group, and today I want to talk about peer review, what to do if you are the doctor under review. So your question is, what is peer review? Peer review is something that you should be familiar with by now if you are a doctor or a healthcare provider working within a hospital entity. And this is because it's a semi-routine process that hospitals go through for quality improvement purposes. But peer review can also indicate a danger to your license and professional reputation if it is the result of a review concerning possible malpractice allegations, adverse incidents, behavioral concerns within your organization, or a pattern or data that reveals that maybe your practice is not up to par to what the organization believes. Any of these types of actions can create a peer review action that prompts the organization to review your performance or the particular incident in question, and if not handled carefully, it could lead to a data bank report and a host of other issues. So let's talk about the process, why peer review was created, so you can understand its background and better appreciate the severity that a peer review action can have on your reputation and career. Peer review was created by the Federal Healthcare Quality Improvement Act. The Federal Healthcare Quality Improvement Act was enacted with the intent of ensuring safe delivery of healthcare services and protection to peer review and the process of reviewing the performance of individual healthcare providers to better provide healthcare services that are safe. And with the idea of trying to make healthcare services more safe came the idea of peer review. We need to have a mechanism by which the services provided can be assessed by peers who can tell us whether or not the care is appropriate and, most importantly, safe for the public. That's why the Healthcare Quality Improvement Act is so important for you as a provider to understand, because it gives immunity to those healthcare entities and those reviewers who will conduct your peer review. Again, we talked about peer review being a sort of routine matter, and sure, that happens, but what we want to talk about more specifically today is when peer review happens as a result of an adverse action or some negative consequence that spurs the entity in reviewing your job and whether you did it appropriately. A lot of the time, people think about peer review in terms of your actual qualities and techniques as a physician or as a healthcare provider, nurse practitioner, for example, but we also see peer review in cases where there are behavioral concerns. Practically, the healthcare organization has the right to initiate peer review if they believe that something that you did as a healthcare provider working for that organization poses a safety risk to the organization or their patients. The peer review process is governed by federal law, and that the Healthcare Quality Improvement Act, while giving immunity to these organizations for engaging in peer review process, also requires them to provide you with due process and to ensure that the review process is in fact fair. The reason might be obvious. The consequences of the peer review process can be serious. So you want to be guaranteed some safety and some protections, and that's what the federal law provides.
Quick break. If you're a healthcare provider or an entrepreneur involved in healthcare and have a legal problem, whether it's compliance, regulatory, DEA, criminal, or any number of legal problems, Chapman Law Group is here to help. Please visit us at chapmanlawgroup.com. Click the link below. Now back to the video.
In order for the organization to avail themselves of the immunity provided by federal law, they need to provide you with a fair process. And that at minimum requires providing you with notice of the proposed action, the reason for the action taken, a notice of the rights to a hearing, and the process and procedures that follow those hearings. Most of the time, we will find policies and procedures and instructions on what to expect of a peer review process within that entity's bylaws, and you should get a copy of that information along with your notice. If you don't get it, you should certainly ask for it, or you should be at minimum aware of it whenever you take a job at an organization, just so that you can make yourself familiar with how that entity approaches peer review. But let's back up a little bit. Before things turn formal and you get a notice of hearing, there's a lot that happens, and that's where I see most people missing an opportunity to call an attorney and really take action before things become formalized. And that's because once you receive a notice of hearing, it's a bit hard to undo the process. You're already locked in, and now you really have no choice but to challenge the allegations that the entity has made and take the case to a hearing. What if you don't want things to become so formal? That's why it's important that you pay attention. If you're getting questioned about a particular adverse incident or a certain data set or performance review concerns, you should immediately ask yourself, what is this about? The organization may not formalize things immediately because they themselves don't want to initiate a formal peer review process unless they don't have to. A lot of organizations in their bylaws have sections that talk about a collegial resolution to internal problems, and that does not result in a data bank report, which we'll talk about next. So before you wait and push things along or choose to ignore that one email from risk management, maybe ask yourself if you need to contact a healthcare attorney, and in that case, you should call Chapman Law Group, and one of our very experienced healthcare attorneys can talk to you about peer review and whether or not you should be concerned. Early action may prevent the peer review process altogether and help you get out of a bad situation early. Now, let's say you didn't notice, and where we're at, you received notice that you have a right to a hearing. What should you do? Well, you should call a healthcare attorney because a peer review hearing is usually particularly complex. And again, the particular way a hearing may be conducted varies from organization to organization because the bylaws are different. But one thing they have in common is that they must follow the Federal Quality Improvement Act and ensure that you are afforded due process. And that includes representation by an attorney, the right to call or examine witnesses and present evidence, including potentially expert opinion, the right to submit a written statement, and the right to have an independent panel review the case before they provide a decision on what to do next. So what are the outcomes of peer review? Well, the outcomes that we're concerned about are those outcomes that have the effect of restricting or suspending your privileges within the organizational entity. And we're concerned about those in particular because those are the ones that are reported to the National Practitioner Data Bank. So if the outcome of a peer review results in a restriction of your privileges, a temporary suspension of your privileges, or you being placed under action plan that requires probationary terms where another physician is supervising your work actively, all of those things are problematic for you because, well, they have to be reported to the data bank. So what's the data bank? Well, if you want to know more about that, you should check out our next video on the National Practitioner Data Bank. Until then, thank you for stepping in and listening to me talk about the peer review process. I hope that was clear. If you have any other questions, just give us a call.
Hey, thank you so much for listening. Please like and subscribe and hit that little bell down on the bottom to receive notifications of our upcoming videos.